Welcome to the 7th special dialogue on properties of property law, the changing epistemology of property law. I'm Aloke Prabhu. I'm a teaching faculty at Jindal Global Law School. And I'll introduce, before giving a context to the entire discussion, I will briefly introduce the panelists to the session. We have today with us Professor Jianlin Chen. He's an associate professor at Melbourne Law School, Australia, and has worked previously at the University of Hong Kong and has research experience both in US and in Asian subcontinent. Professor Jianlin Chen has varied interest, and among them of our concern today is property. Professor Chen has published a very interesting book in 2017 titled The Law and Religious Market Theory, brought out by Cambridge University Press. I welcome you, Professor Chen, to the session today. We have with us Dr. Namita Wahi. Namita Wahi is a senior fellow at Center for Policy Research, New Delhi, where she leads the Land Rights Initiative and is a visiting fellow at the Center for Law and Social Transformation in Bergen. She holds an SJD from Harvard Law School. Namita's research interests are broadly in the areas of property rights, social and economic right, and eminent domain or expropriation law. She has written extensively on these issues and in various academic journals and edited volumes, as well as newspapers and magazines. Namita has taught courses in these areas at Harvard Law School and Department of Government there, and at the National University of Judicial Sciences, Kolkata in India. Before entering academia, Dr. Namita was a litigator with Davis Park and Wardwell in New York. We are also looking forward to the upcoming book, which is titled History of the Fundamental Right to Property in the Indian Constitution. I welcome Dr. Namita Wahi to the session today. We have with us Professor Swati Malik, who is also my colleague at Jindal Law School. Professor Swati Malik has varied interest, and one of them is, of course, property. Professor Swati has research experience in both in United States and in India. I welcome Professor Swati Malik to the discussion today. Before giving a context to this entire theme, because the notion of property, as we all understand, is, generally people call it as a elephant in the dark room, because property as a notion is a very unifying concept, which is for different disciplines, they have their own understanding of what property is as a concept. So for economists, they have a different take on what property is. For lawyers, they have a very different take on what property rights are. For political theorists, property forms one of the basic reasons why state was created. So social contract theory has a very strong foundation on property. So as a concept, this is both a unifying concept, yet it has quite complex and conflicting issues surrounding it. So no two properties seems to be alike. We all identify property in physical things, in ideas, in rights, in legal interest, but none of these property in many sense, there is no relation between those things apart from being called as a property right. But over a period of time, if you look at it as a theoretical understanding, we have multiple theories. We have ancient theories, we have modern theories. All these theories, to some extent, it suggests that the particular theoretical framework that has created has never been sufficient. So we have classical theories which were mostly categorized as a monist theory, which had a value formation, particularly on the concept of, for example, for Locke, it was based on labor. For Hegel, it was based on personhood. For Kant, it was based on libertarian concepts. For Bentham, it was based on the value of efficiency. Also, we have justice-based concept of property. For example, we have entitlement theory from Nozick. We have Rawlsian idea of what property rights are. He has combined it very well with this idea of justice. We have capability approach from Amartya Sen and philosophers like Martha Nussbaum, who have incorporated the ideas of property rights within their theory. So looking at all these theories, the trouble for any property law scholar is to first get a hang of what all theories are there. So we couldn't generally avoid even the ancient theories, because one of the current theories, for example, the theory of human flourishing, has its origin in the Aristotelian idea. So we have to probably start from Aristotle or Socrates, or probably beyond that, to understand, the larger terrain of property. That's the wider terrain we have in front of us. So for any property scholar to get a hang of the larger theoretical framework is a daunting task. So, and especially this is because it's not a purely legal concept. It's equally an economic concept. It's equally a political concept. There are, of course, sociological, anthropological take on it. So as a concept, it has always struggled. It was always in crisis. And apart from the theoretical crisis, we have seen over a period of time, there were factual instances that has happened. For example, World War or pandemic or economic crisis that has forced us to take a relook at the fundamentals of what property is. So now that we have a pandemic going on, one major trouble which I personally find is that this is unlike any other previous crisis, which forces us to take a relook at property, especially because it's an economic crisis, it's having social political crisis. Then we have issues like climate change that has again forced us to think about the basic notion of what property means for the common man. What is a meaningful life for him? What is this human flourishing for him? And how does property rights play out? So considering this particular situation, it's an opportunity for us to unlearn. Now, I'm not being very pessimistic about it, but still, it's an opportunity for us to rethink about the fundamentals of property, and that's what probably the venture today is, to reflect upon the fundamentals of what property rights are, theoretical framework of it, the empirical ideas of it. And today's panelists are from across the spectrum. So I think that that's an added advantage for us. So one of the primary questions which comes to my mind is on the Indian context, and I will ask Professor Dr. Namita Wahi to reflect upon it and give her suggestions. So do you think that, because your work had primarily been on land rights in India, do you think that this most basic concept of our understanding of what property is, probably the first thing that comes to our mind is immovable property or access to land rights? How do we see it in this current situation? Because we have, due to climate change also, we have migrations, we have development projects are there, which has forced us to migrate from one part to the other. And then we have a situation where the current pandemic has taught us that some of the access to material goods may not be enough. The urban space may not be a very conducive environment for a certain section of population. So how important is access to land rights as of now for us? Is it, do we need to go beyond it?
Thank you, Aloke. Thank you for inviting me, and to the organizers, Jindal Global University. Aloke, you've packed in a lot in your opening remarks. And so if I can begin to sort of unpack some of the questions that you've raised. So first of all, the very concept of property rights, I want to talk about that first, and then get on to the pandemic and the climate crisis and all the other things that are happening. So, I think when you spoke about the fact that economists, political theorists lawyers have a different conception of property, I think therein lies the answer. So I think we can only sort of, speak to the issue from the perspective that we are coming from. And the perspective that I have always taken based on, my work on the ground and my understanding of property, which I think is closest to the ground reality, which is this idea that is there in our laws as well, is that property is a bundle of rights. And this comes from Hofeld, it comes from legal realist literature. If property is a bundle of rights, then you're not talking really about the right to a tangible thing. And therein, I think, is a difference between the work that I've done in this space and the economist understanding of property, someone like De Soto's understanding of property, Hernando De Soto's understanding of property, which is that it is not the right to a tangible physical object, but rather property rights are really about rights with respect to something between people. And, as lawyers, we know that property consists of title rights, use rights, possession rights, usufructuary rights, transfer, alienation, inheritance, mortgage, those rights. So it's a bundle of rights. And because it is a bundle of rights, it can be configured in many different ways. So that you can have title, but you may not have possession. You may have possession, but you may not have the right to transfer. You may have title and possession, but you may not have the right to transfer. And if we look at legislation all around us, in fact, we are about to launch this project on mapping Indian land laws, where we've collected and analyzed and summarized over 500 land laws in India. I mean, there's so much laws, so many laws relating to land. And what we find is that we have laws already that create those various configurations of the bundle, whether it is your rent control legislation, which imposes a limitation on your ability as the owner to raise the rent, thereby protecting tenancy rights, or it is your agricultural tenancy reform laws, which exist that actually secure rights to tenants against owners. So we already have laws that recognize different configurations of the bundle. And if that's the case, then it's a question of, what rights are you trying to protect and what rights are you not trying to protect? And I think the work that I'm doing, you mentioned the forthcoming book is, and I think you mentioned a very important concept, which is development. So the argument, as many of our viewers would know, but for those who don't, India had a fundamental right to property in the Constitution, and it was a right that was highly contentious in its adoption. In fact, the debate was most contentious on the adoption of this fundamental right. And then it went through a series of amendments and it was ultimately abolished. So it's the only fundamental right to have been abolished. And the argument that I make in the book is that the contention was really not so much about property, but really about the fundamental conflict that exists between the rights discourse on the one hand, which is a dignitarian discourse in the way that it was conceived by Ambedkar and others in the Constitution, in the sense that not everybody had the same rights in the country that became independent, whether we speak about women's rights or Dalit rights or Adivasi rights. And so when you say that someone has a right to property or a right to life or a right to liberty, you are actually just recognizing equality, the fact that everyone should have those rights. But there is a fundamental contradiction with the development discourse, because that is premised on the state being able to take various measures, depriving people of their land rights and property rights and so on, in order to bring about processes of economic development, which is exactly what you were referring to, which is about displacement of people for big development projects like dams, for your infrastructure projects like highways and airports and things like that. And it is a question of, when we talk about land rights, we are talking about the people who are getting displaced. And these people may have title to the land, they may have possessory rights, there may be a conflict in the way that they recognize their rights to the land vis-a-vis the way the government recognizes the right to land. So that is where, we have to think about that these are also property rights, that they're, people tend to, say land rights versus property rights. I mean, actually, these are also property rights. There may be a certain configuration of the bundle, and there may be a different configuration of the bundle in urban areas. And I think that that's why the issue is not, the property rights were abolished. That might have actually, worked to the disadvantage of people who were marginalized, who were dispossessed, and who were being dispossessed through the process of economic development. I'm mindful of the time, so I'll just quickly respond to the pandemic and climate crisis question. People have different views of the pandemic. I think it'll be a long time before we are able to unpack what the impact of the pandemic has been. My own view of the pandemic is that it has basically exacerbated, highlighted existing inequalities It's just brought to the fore inequalities that were already there, but we were perhaps not so mindful of. And therein, specifically to the pandemic question, lies the question of intellectual property rights. And there, I think, the point that you raised about classic political theory, the advantages to be conferred by property, the balancing of the interests of the people who are putting in their research and innovation versus the public benefit. I think, again, there is a balance that has to be drawn there. And I think that balance can be drawn in different ways. Clearly, the way that balance has been drawn both during the pandemic and previously. I mean, we've had other pandemics, and we've had, other crises like the AIDS crisis, where, the poorer countries like in Africa and all, they were much worse off than the richer countries, and it took a while for that course correction to happen, if it ever happened properly. And we are seeing the same thing again. The new variant that is coming about is because we have not vaccinated people in Africa, and the earlier Delta variant was because we had not been able to vaccinate at that point of time people in India. So I think we'll just keep having variants because we richer countries are going to give booster shots to their population, but the countries that don't have will continue to have variants which are going to spread to other countries, and we're in it together. And I think that's the point of the pandemic, that we're in it together. So I'll stop there and speak in the next round.
So one of the important points which you have raised is on the constitutional understanding of property. I would have some reflections on it from Professor Swati Malik, because she's in academia, and so under the constitutional law, we do not have property as fundamental right, as Dr. Namita has suggested, and it has been repealed in 1978. Even I guess in the United States, they have not taken it as a fundamental right, and there had been multiple systems which have coexisted within a society. For example, one parallel which I would like to draw is about the case of the indigenous population. So the tribals have a very different notion of what property is. Their understanding of property is quite different from what the modern state, the regulations of state, the constitutional framework of state has provided. Professor Swati, do you think that there are there under the constitutional framework, and even when you look at the concept of property within the constitution, do you think that there are possibilities of multiple systems that could exist within the constitutional framework, or the power that the state has shown? Even in the case of the United States, in many other cases, there had been differences, because in some countries you have treaties which has been specifically created between the indigenous population and the state, which came about in 17th century or during the time of the creation of state itself. But in India, that has not happened. We do not have a treaty. So when we have a treaty, it's about a contract between equal partners. But here we have laws which the colonial masters have created. So we have laws that has been constitutional. So how do we see that? Do we understand that the Constitution provides us enough scope and flexibility to coexist within different systems in place?
Thank you for the question, Aloke. So even though I feel that even though we don't have a fundamental right to property anymore, but we still have a legal right to property under Article 300A of the Constitution. So that is one area where we can actually explore the right to property. And as we see, there is a growing trend with the latest court judgments that actually under the doctrine of eminent domain, that, and we have seen the Land Acquisition and Rehabilitation Act 2013 as well, that there are serious questions when the state is interfering with the legal right of property of the individuals as well, that there are questions about lack of compensation to the people who are losing their lands because of different dam projects. We saw this in the Narmada Dam project as well, that there were many people who were displaced from their properties, but they were not adequately compensated. We see this in cases of tribal populations as well. So there are arguments under the Forest Rights Act as well, that we need a greater community participation in order to ensure that property rights are better protected for the marginalized portions of the society. So when I see that, that's why this is the reason that there have been these constant debates about reintroduction of, a fundamental right to property, specifically when we see the situations of marginalized population, because the state has not been active in properly ensuring that these people are effectively compensated under the LAR Act. And there are so many lacuna, even though there have been suggestions that we need to improve the community participation, we need approval from specific portion of the population before the land is actually assigned for different projects. So these issues are actually raising the concern. So I think that when the state is exercising eminent domain, we need to have effective methods of compensation. And that's why we need to effectively recognize the legal right to property and to take it more seriously. So with the introduction of special economic zones, and we saw this in the case of labor codes as well, how the government is repetitively taking a pro-industrialist approach. So we saw this in the case of projects as well. We saw this in the case of nano project as well, when there were greater issues of displacement. So I feel that the state is the one who needs to take an active role. We need to have effective methods of compensation for the people who are losing their rights, because it is difficult to say that, urbanization and industrialization is going to stop at any rate. So that means that we need better methods of coping with the system and to recognize better property rights for the marginalized.
So, these reflections in some sense, because Professor Chen is specifically working on natural resources, I would, the question that comes to my mind is, for Professor Chen, how do you see, because you have worked in 3 different jurisdictions and you are currently teaching in Australia, so in Taiwan, in Hong Kong, in China, we have seen tremendous amount of development, and specifically, on issues of displacement, on issues of compensation. Because in India, probably one of the, as Professor Swati has mentioned, one of the major contention had been the point of contention had been one of compensation. Though in constitutional framework, especially in India, we do not have when we adopted our provisions within the constitution from United States, we have specifically avoided 2 particular clauses which they had. So it's the due process clause and the concept of compensation there. So in India we had diluted so much. But how about how do you see the issue of property rights associated with natural resources?
Oh, so thank you, Aloke, and thank you, Namita and Swati, because I think for this question, it's not just about natural resources, but it's actually relates, or at least what I want to just share is relates to what Namati says about the constitutional rights and what Swati says about the problems relating to eminent domain. In particular, what we can term as perhaps corruption or inefficiency by the government by taking the land but not paying the fair share, but then transferring it perhaps with some side money on the side to reach benefactor, etc. Because I want to speak from the experience of Singapore, which interestingly doesn't have property rights in its constitution as well. But Singapore is also a place in which 80% of the population owns their own home. So it's a place in which, on one hand, there's property right. It's not a constitutional right, but it's a place where many people, including those disadvantaged, what we call disadvantaged and the poor, actually have ownership of many property. And I think this speaks, to what I feel is an important conceptual dichotomy between the way to understand constitutional protection of property rights. And I think there's two parts to it. One is the distinction between the allocation of property rights and the protection thereof. So I think in a sense, the injustice we see nowadays in many parts of the world, developed and developing countries, it's not necessarily a problem of too strong property right protection, but rather insufficient allocation. And I think this is alluded again from what we hear from Nawati and Swati, where after the abolishment of property rights protection in India, there's a task of coming back. But perhaps what the ideal way will be that property right is protected, well protected under the law, but it's also well allocated by the state. And so this leads us to the second dichotomy, is that the constitutional right protection of private property is meant to serve as a constraint of the government. And of course, in the ideal world, the government will use the power afforded to it by the lack of such constitutional protection to take the land and redistribute it, reallocate it to the parties which it deserves. And throughout the process, ensures that those which are allocated, those owners of those property, insofar as the government is not trying to regulate its action or reallocate, have proper legal protection. And so I sometimes see the debate on, and not just on land, this is the same thing with natural resources. It is that tension, that distrust of government which motivate. And perhaps it's not just the motivation for this call for private property right, but it's also the source of the problem caused by the lack of property right, whether in terms of its legal protection or the constitutional protection. And I just want to end off with a bit of research specifically on natural resource rights, which I thought is quite illuminating. So I did a state, I look at the United States, states by state, how they classify cloud water. So basically the water in the cloud as whether are they state-owned or not. And so looking at all 50 states on how they deal with cloud water, there are 4 states which says that cloud water belongs to the state. So basically the state exerting property right, state ownership property rights over those natural resources. But there's another 20, 30 states which have regulation affecting how individual can affect cloud seeding and other forms of weather modification, how they can use those resources. And the interesting finding is that those states which proclaim state ownership over cloud water doesn't actually have more regulation as compared to states which regulate the use of those resources without explicitly saying that those belong to the state. So I think when we look at property rights, I think the takeaway is we must care as much as the governance structure, the underlying government, the efficiency, the lack of corruption, how it exercises power. And I think that is the bigger problem as opposed to whether a certain right is a constitutional right or not.
So the allocation of, the allocation done by the state, because in Singapore, Singapore had migration, and Singapore had all the troubles, probably now UK is having. So Professor Carolyn Hunter has joined us. Carolyn Hunter teaches at York Law School, has done considerable work in the area of housing. And currently, for the last couple of years, UK, like many other European countries, is facing the issue of immigration, and housing is a huge issue there. Professor Carolyn Hunter, do you really see that the issue of housing as something which comes out of the state power, or which has to be inscribed within the constitutional framework, because UK does not have a written constitution? So the kind of normative culture that has created, do you think that UK has something to learn from Singapore, or UK has a very different way of looking at it?
Yeah. Hello, and I'm sorry I'm late. The times moved in November, and I put the wrong time because I put it anyway. I'm really sorry about that. So just to talk about the idea of rights, I have to say I'm a bit of a skeptic about rights, and I suppose that comes from a little bit looking at what happens in South Africa in terms of the right to housing, and what happened in the case of Groom Boot, where she died before she was rehoused. And it seems to me we forget a lot that actually what we need is resources from the state, if it's the state who's going to provide them, because actually giving people rights often doesn't lead to better housing. Or we need to have very particular rights against landlords, if that's the problem, not against the state. And I think that's where I start from. So I write about the rights for, in terms of housing, and and I look at other countries where there's a right to housing. And I think actually, if I look what we have in the UK, we have problems with it, but we have a lot of rights for the individual against whether it's as I say, the landlord, or if they've got a mortgage, against the mortgager. All that sort of thing is more important than a right to housing. And the other thing I suppose I want to talk about, because you're talking about refugees and so on, is of course they have no rights to property. When they get to the country, as we're seeing at the moment, they have absolutely no property at all. And of course, the right to property is of no help to them whatsoever. And so they always have to go to the state, certainly in the UK, for anything and everything. And of course, the state treats them terribly. So I think if we're talking about a right to property, that is not going to help at all.
Right. So one particular idea that comes to my mind when Professor Carolyn Hunter specifically mentioned about the state should have wherewithal, the capacity. So probably Dr. Namita Wahi would be more capable to answer this this problem. The problem is that even when we adopted provisions of property right as fundamental right within the constitutional framework, we have probably created a right-based approach to property rights. That means we were not. So the balancing of obligations in terms of rights, we were more looking at rights rather than obligations. So for some people, when we look at property, they first for them the first thing is that right in person. I have, because my property rights comes out of my person. It's an extension. My any right over external objects, over land, over vehicles, over any other things comes out primarily because I am there. It's a part of my personality. It's an extension of my personality. So if we consider that particular property rights as an extension of my being, then do you see that in the Indian Constitution that we have not been able to understand property rights in its varied dimension? So probably if you look at case laws till 1978, the most contentious issue was on land, on immovable property. But we had the court had been silent with regard to different other forms of property that were existing. For example, my body. What about my body as my property? Because through it, if you look at Aristotle, people have spoken about it, and various theoretical frameworks have already been created. So the contemporary theory of human flourishing, for example, it is based on this Aristotelian notion, and even for Hegel, his idea of personhood theory comes out of first the question that comes out in our mind is that because I am there, I have legitimate interest over external objects because that's how I could live a meaningful life. So this question that the individual is there he does not have access to external objects, but by virtue of being born as a human being and being in a society, I have certain rights, property rights, which is not basically, external, but still fundamentally there are certain other rights which are there. This particular debate has never occurred, or it has occurred, once in a while, and this silence or this vacuum in the constitutional case laws that has emerged till 1978 and even after that, do you think that this is a problem?
Thanks, Aloke. So first of all, I want to say that I agree with Swati and Jianlin that it's the question is not about whether something is a legal right or a constitutional right, but rather we also need to look at the institutions and the processes that are going to enforce those rights. So I'm completely on board with all of you on that. But I do think that and going to your specific question, Aloke, so when we look at the Constituent Assembly that debated the fundamental right to property, actually it's a myth, and this is the thing that I'm trying to sort of set aside with my work, which is that, frankly, the Zamindars pretty much lost in the adoption of the constitutional property clause. And I think the problem was that there was a lot of disparate views within the Constituent Assembly. The Zamindars were, of course, one strong lobby, but and what Swati is talking about, the industrial interests being prioritized. What I argue is that was the formulation that was adopted in the fundamental right to property itself. So it's not something that is happening now. It's happening more now because there's more money for development projects, more industrialization happening now, just scale is more. But in terms of actual commitment to the process of industrialization, capital formation, and economic development, that is what framed the final adoption of the right to property. And, in that sense, that is the fundamental contradiction, which is why I don't, comparative constitutional law, we tend to look at different jurisdictions. I personally don't find it that helpful to look at what has happened in developed countries vis-a-vis what's happening in developing countries who have been former colonies, whether of England or, France or any of these other countries, because the colonial setup was something, you may not need rights in England because you have a well-functioning setup, but when you are colonial, subjects, you need rights. And that was the entire, like, if you look at the Indian the freedom struggle, starting from the 1895 Home Rule Bill, which was at the time of the founding of the Congress, the Indian National Congress, it's all about rights, because you just don't have any rights. You have a completely arbitrary colonial state who can come and, kill you, maim you, like push you out of your house if you want to protest against illegal laws. I mean, there's no illegal laws because the British colonial state decides what exactly it's going to be done. So you need rights. You need all rights. You need rights of property. You need rights to life, liberty, because you don't have that when you're a subject. When you become a citizen is when you have rights. Developing countries people became citizens post-independence. Whether it's South Africa, whether it's India, you don't have rights in an apartheid state. So you do need rights. But I agree with Caroline that it's not, it's a necessary, it's not a sufficient condition. You need resources to back those rights, definitely, but you need rights, because without them you're just subjects and not citizens. So that's the first point. I completely agree with Jianlin as well, that you need to have allocations, and at the same time you need to have protection of property rights. And I think India did embark on that with the land reform laws that were passed. And I'm just completing a study of all property rights cases that were decided by the high courts and the Supreme Courts. This is like thousands of cases. And while it is true that a lot of cases were brought by zamindars, and but a lot of cases were brought by people who were just affected by the big transitions that were happening, and it was not entirely clear how that was going to affect them. And a lot of these cases are also brought by the urban, commercial and industrial interests. So it's not true that there were not different conceptions of property. In fact, what we also find is something we see today is the arbitrary use of criminal law. So a lot of the cases are actually, cases of confiscations, where people have, because it's not just land that was being reformed. There is the Essential Commodities Act, and suddenly there are a lot of disputes about whether you are afoul of the law, and that happens whenever you have a big change in the law, there is a rise in legal disputes. This is what we say in our land acquisition report also, because the law has changed and it has, provided certain greater rights. And which is why I say when you have, rights, you will see more litigation, but that's not necessarily a bad thing. It may lead to more inefficiency in the system, but it may be more equitable, especially because we are in a post-colonial state. I don't think that much has changed. I think constitutions do matter because, so again, the distinction between the post colonies and the ones that were never colonies is the fact that our laws, as you know, have been grandfathered under the Constitution. So we have a lot of colonial laws. We just got rid of the 1894 Land Acquisition Act. So yes, the Constitution matters because the Constitution was a blueprint for the future. And therein, I do think therein is the disagreement that I have in the particular context of India, why constitutional rights matter more than legal rights, because legal rights, like of this 500 laws database that we have created, 500 land laws, 150 are colonial laws. And again, I want to make a nuanced distinction that out of those 150 colonial laws, not all laws are bad, or not all laws are, of a colonial state mindset. Some of those laws are also to protect interests of particular groups like Adivasis. And that brings me to the natural resources law question, as well as the question you posed to me in the first round, which is about climate change. I think I've been working on Adivasi rights for many, many years now. And I think the biggest takeaway I have taken away from that is not that Adivasis need protection, but rather we need to adopt the Adivasi mindset or consciousness of looking at our world. So for example, they don't talk about property, land rights and water rights and as different rights. What they have this concept of Jal Jangal Zameen, which is water, forest, and land. And they understand that we are part of this one ecosystem. Our problem, the reason why climate change is upon us and we are having to battle this is because we never regarded ourselves as part of an ecosystem. We felt that we could go ahead and do whatever we wanted because somewhere we are superior to the rest of the environment. And that is exactly the consciousness which has gotten us into this problem. Whereas the Adivasi consciousness is that the forest, the land, and the water is part of an ecosystem, and you can't just go in and destroy the forest to bring out coal because you want to provide electricity to everyone without understanding that there are going to be disastrous consequences, especially if you do it at a scale and in ecologically fragile and sensitive areas without doing processes properly. And that brings me to the point about the fact that we don't really have a state where processes work. I have been I've obviously been in the policy space, in the academic space. I've also been a lawyer. And I have been part of projects. I have seen, how, the process that is supposed to be followed is being followed. But minutes of public hearings are doctored. Something is said in the public hearing and something else is reported. Even when an environment impact assessment is conducted, I have seen in the Mundra case, for example, that a different location is given for the project on the basis of which the EIA is cleared, and and actually the project is on a different location. Where if it was fact, and these are like government bodies that are doing these studies. So there is a lot of corruption, you can call it, or you can call it a complete sort of state industrial nexus that allows for these things to happen, that allows for us to basically operate on greed and not see ourselves as part of a larger ecosystem. And that's what leads us to issues. And then we talk about, natural resources, management and things like that. But I think, more than doing for Adivasi land rights, I think if we adopt the Adivasi mindset or the indigenous people's mindset, I think we'd probably all benefit and make the world a better place.
To some extent, you are directly critiquing this idea of seeing property as subject to market. So, because property becomes so contested because it is subjected to market, that means, we are not attuned to seeing, for example, for a indigenous person, it does not occur in his mind that this should be sold. This is my mother. The land is my mother. It's as you rightly said. It's a part of me. I'm a part of the land. So this is not to be subjected to the market for commercial interest. And this particular idea, that I would like to come to Professor Swati. Do you do you agree that the kind of laws that we had, the constitutional framework that we had, so probably in terms of rights, or even sometimes creating, because for a indigenous person, it's not through the constitution that these rights flows to him. He had been there state. He had been there, he had already existed. So how do you see that the kind of conflict that we see can be resolved, because the constitutional framework to a large extent have failed the tribal population over a period of time?
I completely agree that, we need a change in the system. And earlier you were talking about theory of human flourishing, and you were saying that, we need to think about, the good of the society and good of the others as well when we are theorizing the property rights, right? So this also comes to my mind when it comes to rights of Adivasi communities and other marginalized groups as well, that perhaps just having if having a constitutional right was in itself a solution, then this would not have caused so many legal battles, which eventually led to, abolition of the right to property. So just having a right, as Professor Caroline mentioned, is not enough. We need a effective system of enforcement of that right as well. So when I see what I see is a solution in terms of, the theory you were talking about, theory of maximizing human welfare, theory of flourishing. And that was Professor Amartya Sen's idea as well, that when we talk about, resources, we have to see, the impact of those resources as well. So when we look at the rights of the marginalized group specifically, like, in the pandemic, we saw how the economic divide is increasing, how we saw that this has been labeled as a pandemic of inequality, basically how we saw how rich people are actually boarding jets and leaving the country. On the other hand, then we have people belonging to certain sectors of the society who are not even vaccinated. And as Professor Wahi was talking about, that how we see that in African countries also, we see that because of lack of resources, how we are on the third wave now, right? So what I feel that this is a problem inherently. What you are hinting at is a problem of inequality of resources which exists in the society, and whether we can solve it through constitutionally recognizing a right to property, or whether having a legal right in itself is enough. So what I feel is that we need a better state intervention when it comes to protection of the rights of the communities like Adivasi communities. Second is we need to think about this in terms of distributive justice theories, that resources need to be better allocated and not concentrated to the limited few, which is causing these problems. Because on the one hand, we saw during the pandemic how the economic divide is actually increasing, and on the other hand, if we look at the statistics, only 30% population of the world actually owns the land, right? That is the reality. So just saying we have a constitutional right of property is not enough. We need an effective method of enforcement of that right as well, because in the pandemic it has been also seen, there have been arguments about better recognition of rights of property for women as well. We saw during the pandemic how because of lack of property rights, when women were losing their jobs and when they have the entire burden of their family care and they were struggling with issues of domestic violence as well, having better property rights may have solved some of their problems in these times. So same comes to Adivasis and communities. So when we are going for all these projects and when we are going for displacement of communities, we still need some bare minimum. Like we saw during the pandemic how the government, there have been arguments about relaxation of IPR, right? So because the idea is that the governments are also promoting the research to a certain extent when it comes to vaccines. So it would be better to relax the intellectual property rights for a while, and eventually, when the pandemic is better controlled, then we can talk about stronger property rights. So I feel that it's important to talk about distribution of resources in an effective way. We also saw measures like by the government of Delhi when they were actually requesting the hotel owners to use their premises as hospitals basically. So again, there is a private right of property there, but then we were talking about relaxation of that right for the benefit of greater public. So the solution I see here is that we have to start thinking beyond oneself. We have to start thinking in terms of human flourishing as well when it comes to property rights, because when we talk about the right to property, we also have to think about right to health, right to freedom, and we have to think about the idea of flourishing as a society as a whole. So we just cannot argue always, so we have to think more about for this in terms of better distribution of rights rather than just talking about recognition of right to property.
That we have the same in the UK in terms of, actually we did some things which are unthinkable actually in the pandemic. So we stopped evicting any tenants. So nobody was evicted, and homeless people were all largely put in hotels. So we had nobody on the streets. So it can be done if we want to.
Yeah, I was just about to ask you this particular question that there are some interesting models that exist, especially some of your works have given alternatives in comparison to ownership. You have said that housing can be provided by different kinds of models. Do you think that that especially in the context of migration, do you think that there are certain models that can be replicated around the world? Because this is not just a problem with UK or some of the European countries, but also the problem of housing. This is a basic requirement, as Swati is saying. There can be different models that can be replicated. Do you think that some alternative methods are there possible?
I'm not sure that we have other models. Our models are basically on around property rights. So, and different levels of property rights, from having no rights up to some, a license to be in some place up to ownership. And I think our problem is we certainly in the West, and I don't know, if there are other models elsewhere, but essentially we idolize ownership, and that's our problem, individual ownership. And that's what our rights to property are based on. And we need to think a lot more about relationships rather than ownership.
Can I just jump in on Carolyn's point? So, and just add to that, I think not only must we think more about ownership in addition to relationship, I think we need to think on two further dimensions. So one, I think has been alluded to, and that is the responsibility which comes with ownership rights, right? That if you own something, what must you do for the community? But I think another aspect, which I think is just as important, but much less talked about, I suppose because of its controversy, is that it also, when we talk about ownership rights, property rights, it also have to come with the ability to use it wisely to advance the benefit on its owner. So I think this is particularly important when we look at the allocation. So we know that, and I think that the team coming out, especially from Swati, is that, which I agree, is the government must allocate resource, and this is what Karen says, to allocate resource, give property rights to those which are disadvantaged. And of course, once given, I think the issue of them misusing it to the detriment of community, that is not much an issue. That's more for big corporation and whatnot. But what is actually just as important is, do they have the capability to use those property rights allocated to them efficiently to advance their own interests? And we know that utilization of property, resource, money management, financial resource management is a skill which takes time and resource to acquire. And so this is where, if Singapore experiences anything to go by, it suggests that some form of controversial but perhaps necessary paternalistic restriction on the use of those property rights which are allocated to the disadvantaged community may be warranted, at least in the initial transition phase, such that they can build up. So to put it again, one key aspect why Singapore can achieve 80% home ownership is because it has a compulsory saving scheme. So the way it forces the population to finance, to devote, to ensure that they can finance the mortgage, is by requiring them to set aside like 20% of their salary into a fund which can be only used to service the mortgage. So it actually restricts, in a sense, their rights to their own money in a way such that for the greater good, so they direct them away from consumption, which it doesn't build wealth, into investment, which is their own home, which can build wealth. So I think that is the aspect which I'm just throwing out there. I'm not endorsing it. And of course, Singapore is a small island, much less population. So whatever experience it doesn't necessarily can be generalized anywhere elsewhere. But it does suggest it does indicate that looking at how to build out the capability of property right owners to manage their resource to their own benefit is something which any allocation scheme must pay attention to.
We were just about to scratch the skin of property rights, and time is running out. So I would come up with an audience question. This can be addressed by anyone, especially this is a question that is significant for different jurisdictions. It's on climate change. So from the audience, the question has been put. So climate change induced migration brings demographic changes in neighboring states. How does this affect the approach of native people on their property, especially considering tribal rights on property? So for example, climate change has also suggested that over a period of time, some of the low-lying areas would be underwater. So it's not just applicable to tribal population, but also to people who are well settled in places like Bombay or probably in Singapore. How do you see it? I would like quick comments from all the panelists. Professor Carolyn Hunter.
Sorry, goodness, that's a big question. I'm not sure. Well, I don't think individual property rights will help with this. I think we need to think bigger. We need to think about our relationship. So in the UK, we do have issues of storms and so on, making huge difference. We've just had one the last week where the electricity is still not back on for certain areas of the country for a week, which for us seems terrible. So I guess we have to think about this in terms of our relationship with each other across the world. I'm not convinced that property rights is the way to deal with that.
Professor Chen?
So my sense is that perhaps I'm looking at a dystopian future where climate change will be equal to some massive natural disaster, and in a sense to mitigate and manage all the fallout, it will require state to almost take on a war footing in which it have more power, hopefully with more responsibility, and use those power, but to really like in a context of a war setting, make drastic, radical and dramatic reallocation, rearrangement of resources to meet, to ensure the proper survival of a huge chunk of population, which is a factor. But of course, it is a very dystopian future because whenever government has so much power, it never looks good, right? So,
Professor Swati, Malik.
I feel that property rights can be one of the solutions for this, because when we talk about climate change, basically we are talking about resources, and when we talk about resources, we talk about property rights. So studies have suggest that better property rights and effective allocation of resources actually have good impact on environment. For example, there was a study which was done in Ethiopia, where it was found that once property rights were recognized for general public, they started, using better techniques for agriculture, and it had positive impacts on food security. Also, recognition if property rights, like there was this example of Indonesia, where in the Sembugan region, when the rainforests were depleting, but when property rights were allocated, then there was a drive for reforestation, and it has improved the situation. I feel that we need better management of resources, so I would like to argue for better recognition of property rights, but along with it a better distribution of it, of the property rights as well. So we need to involve the community, as Professor Caroline was mentioning about relationships. So we need to focus on our relationship with the resources and our relationship with the environment. And I believe that having better property rights and ensuring better property rights for greater public will encourage community participation, and better community participation will have positive impact on the environment, and it will help in addressing the challenges posed by climate change. We saw this, like for example, in the Chipko movement, where community was greatly involved, and they were involved in the to stop the deforestation. So because forest resources, climate change at the end of the day is result of misuse of resources. That is one of the reasons. So better allocation of resources through property rights can be one of the possible solutions for addressing this problem.
Dr. Namita Wahi, your closing comments?
Yeah, thank you. I just want to say that, even without the climate crisis, Adivasis or indigenous communities all over the world have disproportionately borne the burden of economic development. Just to give some statistics from India, Adivasis in India constitute only 8.6% of our population, but they constitute 40% of the people who have been displaced for economic development projects, mostly dams, mines, wildlife parks, and sanctuaries. In the 50-year period from 1950 to 1999, they constitute 40% of the population that has been displaced, including some who have been displaced twice in one lifetime. So just to put that out there, because they have already borne the burden of economic development, I think the answer to the question that you're posing, like what's going to happen when we have this major climate crisis, I think it goes back to what we started out with, Aloke, which is the free market versus the state. So for example, if you have an environmental disaster, whether it's the California wildfires, or it's the hurricanes, or it is the flooding that we've had with cyclones and so on in India. I mean, if you are rich, you'll buy insurance for your home, right? So in any crisis, if you leave it to the market, the rich are going to turn out better than the poor. But if we take Jianlin's example of Singapore, if the state forces or provides, or what Caroline was saying, what the UK government has done during the pandemic is to make sure that everyone has insurance or everyone has some social security protection, we can actually mitigate that. And I just want to say this because I think what's happened is that because there has been so many issues with the way the state has functioned, at least in the policy space, we are seeing a withdrawal of the state. In fact, we are seeing in India today, we are seeing privatization of many state, institutions and organizations that have actually done well. So we are seeing a complete shift to a privatization model without any understanding and perhaps almost an assurance that the free market is never going to work out well for the underprivileged. And yet we are seeing this sort of handover to the private sector of so many things. So I think we have to, definitely, I mean, have rights, hold the state accountable. For me, rights are an accountability mechanism. And I completely agree with Caroline and others that, you have to have those rights against other people as well. Like horizontality in application of rights is as important as the vertical individual state relationship. But I think we have to be, and that leads to the larger political theory questions that you started out with, Aloke, is that the role of the state, the relationship of the state to property and to economic development, and the role of the private sector and the role of the free market. And I think those are questions that probably deserve continued discussion in the coming days.
I'm so thankful to every panelist. Actually, we have crossed the mandate on time. I hope this would be a continuing dialogue. At some point of time, we will again continue with this dialogue. And I'm so thankful that I had been given this opportunity to be part of this discussion, even in a small way. Thank you so much.